Good morning, everyone. I hope that everyone can hear me. It seems that Zoom has decided to have some challenges the last couple of days. So it wanted to make sure that we were really on our toes for our very first webinar. So I am Lori Shepard. I am the Plan Giving Manager for Arizona Humane Society. I want to welcome you all to our the Humane Society's very first ever estate planning webinar. The webinar style event, as I just said, is still new for us as it is for all of you, but we're just going to figure it out together as we go along. And so I'm going to start with just a quick note of housekeeping, which is that in this webinar, if everything goes according to plan, you can see us, but we will not be able to see you. So we'll probably do crazy things on this end, but if you are in your pajamas and hanging out on that side, you are set. You are good to go. Even though this is a webinar, we want it to be as interactive as possible in this format. So please make sure you send us your questions and your comments as we go through this presentation, especially when we introduce you to our panelists at the end, who will be able to answer questions that you might have. Depending upon your Zoom setup, your Q&A box will either be a little box at the top or a little box at the bottom that you should be able to find there. Okay, so with all of that being said, some of you may remember our in-person format, which was our in-person format, which was a little more, which was definitely more interactive. We called it Wills, Wine, and Wags. And just like today, we brought folks together to talk about estate planning, to meet and play with a few puppies and kittens, and to enjoy some refreshments. Thanks to our new normal, thanks to COVID, we couldn't incorporate all of the past components of that event into this new virtual format, but we think that you're going to find this one just as informative. And we promise that you will at least get to see some pictures of some puppies and some kittens, and I think even a bunny along the way. So bear with us and we'll see what we can do. You know, so much has changed in our lives recently that it's really easy for us to miss what hasn't changed. The things that have stayed steadfast. At Arizona Humane Society, what hasn't changed is that we're still working with committed friends and supporters, just like each of you, to be here for the Valley's sick, injured, and abused animals. In fact, so far this year, AHS has rescued more than 3,500 animals, and our emergency animal medical technicians have fielded more than 5,100 calls for animals in distress throughout the Valley. We have provided life-saving treatment to more than 6,000 animals at our Second Chance Animal Trauma Hospital. We have cared for more than 1,100 tiny, fragile kittens in our kitten nursery and in our bottle baby intensive care unit. We've treated 250 critically ill puppies and dogs in our Parvo Puppy ICU. And we've helped more than 160 new moms and their pups in our maternity suites. You know, at the beginning of this year, none of us could have imagined that we would soon be wondering, how are we going to keep the bottle baby ICU going without our committed and highly trained volunteers? It had not even occurred to us that it was going to become a challenge to keep our EAMTs safely on the road, or to create safe environments so that our clinicians and our animal care technicians were able to stay healthy so that they could continue to care for the animals in their charge. But I'm so proud to say that that's exactly what we did. Our values at Arizona Humane Society have always been innovation, compassion, excellence. Now, this challenging year, we have had more opportunities than we ever wanted to see those values in action. In fact, some of those innovations have turned into permanent changes at the Humane Society. We're calling those COVID keepers. These are new policies or procedures that we implemented during COVID that turned out to be so successful that we're going to keep them even as we return to normal, whatever that means, whenever that means. So one of our favorites is actually in our adoptions process that I want to tell you about. When COVID hit, we knew that we still had a shelter full of animals that we had to help find their new loving and forever homes. So in spite of the need for us humans to social distance, we still needed to be able to connect humans and pets. our teams developed a new virtual adoption matchmaking program where potential adopters looked for their adoptable pets online, chose up to 2 or 3 pets that they wanted to meet. Then they scheduled an appointment, and our adoption specialists were super careful to only book an appointment, one appointment per staff per hour. And then on the day of that appointment, the adopter gets to come in and meet their potential new best friend in a safe, one-on-one meet and greet area or room. This process ensured that we were able to continue finding homes for pets, but also kept everyone safe, not just the adopters, but also our staff. And the exciting part for us was that we noticed that our return rates actually dropped significantly. While some of that's attributed to the fact that people were staying home with their pets, we also recognized that adopters were getting a much more thorough experience with the animals before they made the decision to adopt. And we didn't stop with just our adoptions in terms of our COVID keepers. Another really exciting COVID keeper that we have is telemedicine, which was completely new to us. So with our foster animals, many of them are in foster care because of medical concerns or issues that we're trying to work them through before they're ready for adoption. What we found was by using telemedicine, the foster families were able to stay safe, the clinicians were able to stay safe, and we were able to not put the stress on the animals of needing to come in for follow-up visits or general checkups. It turned out to be a wonderful benefit that we had never envisioned. And then finally, one that anyone who knows me knows that I need for my dog Percy is virtual pet training. We found that folks who were home with their pets were having more and more challenges. And so our animal experience teams opened up virtual appointments so that they could help owners turn around some of the most challenging behaviors without them having to bring them into the Humane Society. One of the big things for us, the reason that we were able at the Humane Society to create these innovations and these compassionate programs is because of the unwavering support that we have from our donors. Whether it is somebody who is enrolled in our monthly giving program known as Constant Companions, or somebody who has committed to our annual giving program, the President's Club, or somebody who just makes that one-time life estate gift, our donors are absolutely the life of Arizona Humane Society. Today, we're talking about estate planning. And if during that process that you decide that you want to include AHS in your will, your trust, or other estate plans, you're going to be leaving a legacy that will last for generations. We call this group of amazing friends Legacy Circle. Legacy Circle gifts are so special to us because they truly ensure the future of Arizona Humane Society, and they ensure that our mission to save the most vulnerable pets and to enrich the lives of pets and people goes on indefinitely. When you include AHS in your final giving plans, it also means that you get to enjoy the benefits during your lifetime. When you become a member of AHS's Legacy Circle, we recognize you on our Legacy Circle wall at our South Mountain campus, the 9M Mason Pulliam campus for Compassion. You will receive invitations to Legacy Circle education events, which we really hope will one day be in person again. And you are eligible to enroll your pets in our continuing care program. Now, I have to say that I really hope that at least a few of you who signed on today did so because you'd already heard about our continuing care program and you were interested in learning more about it. This is such a wonderful program, and what it does is it helps us find new forever families for your pets should they outlive you. And it really gives the pet owner a peace of mind as they're making their plans for the future. Basically, it ensures a bright future for your pets, even if you don't get to be the one that's here to provide it. Pets enrolled in our continuing care are placed with new families that are specially selected from pet profiles that you get to fill out. We have dog, cat, and critter profiles. And what you get to tell us when you fill those forms out is a little bit everything about your animal. And if your animals are quirky like mine, it's really fun. You get to tell us where they like to sleep, what foods do they eat, are they bonded with another animal in the house, do they have any health concerns that AHS and a future adopter need to consider so that we can help them with those. Vanessa Cornwall and I will both tell you that our very favorite part of our job is when we get your pet profiles back and we get to read them and share them with each other. It just makes my day. So I could actually tell you a tremendous number of stories about all those pet profiles, but then we wouldn't actually get to the part that we're here for. So I'm going to actually take a moment and I'm going to introduce you to Vanessa Cornwall. And Vanessa is our plan giving specialist on staff, and she is the person that you will most likely talk to if you call in with a question about Legacy Circle or continuing care. She is the one who will make sure you get the invites to those Legacy Circle education events. And today she is going to give you a really nice overview of a variety of vehicles that you can choose from as you consider your own plan giving and some strategies for charitable giving. And then when she's done with that, she's going to introduce you to our amazing panel of experts, our plan giving committee, those people that are in the field that are going to answer your specific questions. So Vanessa?
Well, thank you, Lori, and thank you to everyone for attending today. As Lori said, I'm going to give you all an overview of an array of estate planning tools, as well as a few examples of how you can incorporate a philanthropic element into your final giving plans. Today, we'll talk about wills, trusts, charitable trusts, payable on death and transfer on death accounts, charitable gift annuities, real estate, real property, and beneficiary designations. We recognize that this is a lot of information and that everyone's situation is unique. So be sure to jot down your questions as they come up and submit them through the Q&A feature, and our panel of experts will be happy to address them during the question and answer session at the end of the presentation. We will begin by discussing wills and trusts, which are two of the most common planning devices. Some people think that only the very wealthy or those with complicated assets need wills. However, there are many good reasons to have a will. A will is a legal document that spells out your wishes regarding care of your children, as well as distribution of your assets after your death. You can decide who gets what and how much, and your heirs will have a faster and easier time getting access to your assets. Without a will in place, the courts make these decisions for you. A trust, on the other hand, is a separate legal entity a person sets up to manage his or her assets. With a trust, you have to follow the legal formalities of the trust. Be sure to name the trust as legal owner of property and manage it as the trustee. That means deeds to real estate must be reissued in the trust's name, titles to vehicles and some other assets have to be reissued, and names on financial accounts might have to be changed. Many people have trusts drafted, but then don't transfer legal title of their property to the trusts, so the trusts have no value. Your attorney will guide you in this process to ensure that your trust works the way you intended. In both a will and a trust, you can leave a beneficiary a specific bequest, meaning a set dollar figure or items of personal property. You can leave a percentage of your overall estate, or you can leave the remainder or residue of your estate, which includes anything that is not designated to other beneficiaries. Some of the differences between a will and a trust include: a will goes into effect only after you die, whereas a trust takes effect as soon as you create it. A will direct who will receive your property at your death, whereas a trust can be used to begin distributing property before death, at death, or afterwards. A will appoints a legal representative to carry out your wishes, whereas a trust is a legal arrangement through which one person or an institution, such as a bank or a law firm, called a trustee, holds legal title to property for another person, called a beneficiary. A will covers any property that is only in your name when you die. It does not cover property held in joint tenancy or in a trust, whereas a trust covers only the property that has been transferred into it. A will passes through probate, which means a court oversees the administration of the will and ensures the will is valid and the property gets distributed the way the deceased wanted. A trust, however, passes outside of probate, so a court does not need to oversee the process, which can save time and money. A will becomes part of the public record, but a trust can remain private. A will allow you to name a guardian for your children and specify funeral arrangements. and a trust can be used to plan for disability or to provide savings on taxes. Every estate should likely have a will and is likely to have at least one trust. The issue is which vehicle you use to transfer the bulk of your wealth to the next owners. We recommend that you work with an experienced estate planner to determine which fits best with your estate and your goals for cost, efficiency, privacy, and more. There are two basic types of trusts: a revocable trust, also known as a revocable living trust or simply a living trust, and an irrevocable trust. The owner of a revocable trust may change its terms at any time. He or she can remove beneficiaries, designate new ones, and modify stipulations as to how assets within the trusts are managed. In contrast, the terms of an irrevocable trust are set in stone when the agreement is signed. Except under exceedingly rare circumstances, no changes may be made to an irrevocable trust. The main reason to select an irrevocable trust is for tax purposes. There are also charitable trusts, and the most common type of charitable trust is a charitable remainder trust, which is a tax-exempt irrevocable trust designed to reduce the taxable income of the individuals by first dispersing income to the beneficiaries of the trust for a specified period of time, and then donating the remainder of the trust to the designated charity. This is a split interest giving vehicle that allows a trustor to make contributions, be eligible for a partial tax deduction, and donate remaining assets. There are two main types of charitable remainder trusts: a charitable remainder annuity trust, or a CRAT, which distributes a fixed annuity each year, and a charitable remainder unitrust, or a CRUT, which distributes a fixed annual percentage based on the balance of the trust assets. CRATs do not allow for additional contributions after the trust has been established, while CRUTs do permit additional contributions. Next, we'll talk about payable on death accounts. This is an arrangement between a bank or credit union and a client that designates beneficiaries to receive all of a client's assets. The immediate transfer of assets is triggered by the death of the client. People who opt for POD accounts do so to keep their money out of probate court in the event they pass away. To set up a POD account, the financial institution will provide a beneficiary designation form to be completed by the account owner. The named beneficiary can be an individual or a nonprofit organization. The named beneficiary is not entitled to any of the money in the account while the account holder is still alive, but upon death, the beneficiary automatically becomes the owner of the account. A POD is more powerful than a last will and testament. If a POD account has one individual named as the beneficiary and the will of the account holder lists another individual as the beneficiary, the POD designated beneficiary prevails. A transfer on death arrangement is similar to a POD, but deals with stocks, bonds, mutual funds, or other investment assets rather than bank assets. Next, we'll talk about charitable gift annuities. A charitable gift annuity is a contract between a donor and a nonprofit organization in which the donor makes a gift to the charity and in return receives a regular, fixed payment for life based on their age and the value of assets transferred to the organization. After the donor's death, the assets are retained by the organization. Charitable gift annuities can be established at the Arizona Humane Society with a minimum gift of $10,000 in the form of cash or appreciated securities for donors who are age 55 and older. The annuity rate is based on the current rates established by the American Council on Gift Annuities, and payments are made on a quarterly basis. CGAs through AHS can be for 1 or 2 lives, meaning that the original income recipient can designate a secondary income beneficiary to receive the annuity payout upon his or her passing. In this circumstance, the rate of the CGA is based on the younger of the 2 individuals. Upon the death of the last life income beneficiary, the remaining principal balance of the annuity is released for use by AHS. This is just a reminder to go ahead and submit your questions in the Q&A box at the top or bottom of your screen, and we will go ahead and answer those at the conclusion of the presentation. Real estate. In the state of Arizona, beneficiaries to real estate can be designated through a will, trust, or beneficiary deed. With an Arizona beneficiary deed, the owner of real property located in Arizona may convey his or her interest in the property to individuals or entities following his or her death. Benefits include avoiding the probate process, It's a more simple option than creating a trust, and there is no gift tax liability. The owner is free to change an Arizona beneficiary deed at any time. He or she may sell, encumber, or otherwise deal with their property without any restrictions or limitations, and the Arizona beneficiary deed can be revoked at any time. The Arizona Humane Society does accept gifts of real estate, but we are not in the real estate business. As such, we recommend leaving the proceeds from the sale of real estate to AHS and appointing a personal representative, trustee, attorney, fiduciary, or other third party to facilitate the sale of the property. We are, however, in the car business. Our thrift store manager, Greg Verga, recently got his dealer's license to help maximize the revenue received from vehicles donated to AHS. In fact, he just celebrated his 50th car sale. So if you are thinking about donating your car either now or as part of your estate, we certainly encourage you to think about donating it to AHS. We will turn your vehicle into life-saving care for the dogs, cats, puppies, and kittens who come through our doors each and every day. Another great option provided by the thrift store team is for donations of real property. We have several Legacy Circle members who have donated the contents of their homes to AHS. For those who don't have family or who don't want to burden their family members with the task of packing up their belongings after they pass, AHS is here to help. Our thrift store staff, along with volunteers, will come in and do just that for anyone who has included this provision in their estate plans. Lastly, we will discuss beneficiary designations. Life insurance, IRAs, and other retirement assets can pass to beneficiaries outside of your estate, which is to say they are not subject to the probate process or trust administration. When you name a charity to receive your IRA or other retirement assets upon your death, neither you or your heirs nor your estate will pay income taxes on the distribution of the assets. Your estate will need to include the value of the assets as part of the gross estate, but will receive a tax deduction for the charitable contribution, which can be used to offset the estate taxes. Because charities do not pay income tax, the full amount of your retirement account will directly benefit the charity of your choice. It's possible to divide your retirement assets between charities and heirs according to any percentage you choose. And this gives you the opportunity to support a cause you care about as part of your legacy. Now I would like to introduce our esteemed estate planning experts and members of our Planned Giving Committee. Andrea Claus is our committee chair and an estate planning attorney with Bivens & Associates. Kathy Knapp is an estate planning attorney with Fraser, Ryan, Goldberg, and Arnold. James McGittigan is senior manager of financial planning with Stoker Ostler. Troy McNeamer is an estate planning attorney with McNeamer Law Offices. Harry Papp is managing partner and portfolio manager with the wealth management firm Elroy Papp & Associates. And Pamela Wheeler is the principal with the accounting firm Henry & Horn, where she specializes in the taxation of trusts and estates as part of their estate, gifts, and trust department. Thank you all for being with us today. All right, if you all could unmute, and we can answer some questions. All right, so our first question I'm going to throw at Troy, and the question is, how do I create a trust?
So best way to create a trust would be to work with a professional attorney. And essentially the way it's done is to sit down with the attorney, talk about your objectives, who your family is, what assets you have, what you would like to have happen to your assets upon your death, who you would like to help administer your affairs if you die or become incapacitated. And together, you'll work as a team to develop those objectives into an actual trust document that will accomplish your objectives upon your death or incapacity. As was mentioned earlier, one of the important parts of the trust will be funding the trust, and you will work with your attorney to make sure that that is done properly.
Thank you, Troy. Okay, the next one for Pamela. What tax returns need to be filed upon my death?
Well, unfortunately, taxes don't go away when you pass away. Your trustee or personal representative will have to file the final individual tax return for you, which will cover January 1 through your date of death. After that, the trust or the estate needs to start filing income tax returns. They're called fiduciary income tax returns. That begin the day after you died and will go through the point in time where all of your assets are ultimately distributed to your beneficiaries. So that could only be, maybe a 1, 2, maybe 3 years worth of tax returns, depending on how long it takes to distribute your estate. And then there could also potentially be an estate tax return due. If when you pass away, your gross estate is valued, a gross estate plus any taxable gifts that were made during life is valued at over $11,580,000 this year, which means usually a married couple can have more than $23 million before an estate tax return would be required. But if that's the case, an estate tax return would be filed. There could potentially be some estate tax due at that point. Surviving spouse, perhaps not, because you can give your assets to your surviving spouse and avoid the estate tax on the first death. That exemption amount is scheduled to drop back to $5 million plus annual increases in the end of 2026. So there's some planning that needs to be done here, because you may want to file an estate tax return to use the portability election, which means if there's a surviving spouse, first spouse dies, you file an estate tax return and use whatever exemption the first spouse had, port it over to the surviving spouse. So they now not only have their own exemption to use on their death, plus the amount of the exemption that was ported over to them, which can give them a lower taxable estate potentially on the second death.
Thank you, Pamela. Okay, the next one I'm going to ask to Andrea. What is a certified fiduciary versus an attorney? What would typical duties be? And what are the qualifications of a certified fiduciary? How are they viewed by the court? And are they insured and bonded? And ask me if you want me to repeat any of that.
Well, that's fine. So what I'll do is I'll answer the question, and if there's something that I missed, I'm confident you'll let me know. So a professional fiduciary receives certification through the Arizona Supreme Court, and their duties can range from acting as a healthcare agent to acting as a financial power of attorney, acting as personal representative in a probate, acting as successor trustee in a trust administration. So it's a fiduciary role, meaning they're acting for the interests and on behalf of the interests of another person. They step into the role either usually because of death or incapacity, and they are, if we're talking about an appointment made through an instrument, like a power of attorney or a will or a trust, they're bound by the terms of that document. They all carry professional bonds if they're licensed fiduciaries. The difference there is that an attorney's role is usually that of drafting and then assistance with administration. So, I'm sure just like me, the rest of the attorneys that are part of the panel do represent fiduciary clients. So, we represent professional fiduciaries, banks, trust companies as they carry out their role. So I guess the main difference in like a post-death administration, if an attorney and a professional fiduciary are working together, is that the professional fiduciary is kind of the boots on the ground, doing the actual administrative work, and the attorneys providing legal guidance through the administration process. And I think I hit them all, but I'm not sure.
I think the only part was, are they insured or bonded?
So yes, there are statutory insurances and bonds that they need to have in place before the Supreme Court licenses.
Thank you. All right. Let's see. So we have somebody who has already left a portion of their estate to AHS, and they're wondering where they return their continuing care forms and statement of testamentary provision. So you can actually send those back to me or Lori via email, or you can mail them to our Dobbins address. And at the end of this, we'll put up a slide that'll have our Legacy Circle email address. You can send them there, legacycircle@azhumane.org. And thank you. All right, next, Kathy, how often should I revisit my estate plans?
Good morning. There are really no set rules. If there's a major change in either state law or in federal estate tax law, then it's appropriate to just go over it to make sure that those changes do not affect how you've made your existing plan. Also, if there are life changes that have happened, marriage, divorce, children, grandchildren, it's good to take a look and see if that may have changed how you want to plan for your remaining property when you pass away. Also, it's good, oftentimes people will name a family member or a friend, a trusted friend, to act as fiduciary. And sometimes when there's a period of time that elapses between signing the document and those relationships may change, or something might happen to one of the people that you've designated to serve. So it's also good to go back and make sure that the people that you've designated in a fiduciary role and a trusted role are, you still have a good relationship with them and you trust that they will follow your wishes and act prudently.
Thank you. And then we have 2 questions that relate to continuing care. So I'm going to send those your way, Lori. The first is, how do I provide for my pets when I am no longer here? And the next is, I currently have family lined up to take my pets when I pass. How can I utilize the continuing care program?
Those are kind of one and the same. So we did talk just briefly about continuing care earlier, and just to reiterate, it is this wonderful program that AHS provides so that you can plan for your animals. Some of our attorneys, Kathy, Troy, Andrea, will tell you that some people choose to do a trust for their pets. They can be a bit complicated, they can be cumbersome, and they can also not work the way that you had intended them to. So a lot of times people will choose our continuing care program because it allows you to know that your animals are going to be taken care of. You might not be able to say the exact person, but you know that at AHS, our staff is going to be sure that the right person is chosen to care for your pets. And then if you have already chosen someone in your family who said, yes, I would be happy to take your pets, I think it's still a great thing to enroll in continuing care. And the reason is because you don't know for sure that that situation won't change. And continuing care is a wonderful backup. So just because my brother-in-law might say today, yes, he's going to take care of my animals. All those who work with me know I always reference our dog Percy. We have 2 dogs, 2 cats, 3 are normal, and then we have Percy. He may spend some time with Percy and say, oh heavens, this dog is so spastic. I cannot take this dog into my family and into my life. And if I've enrolled him in continuing care, then I know that there's going to be a really solid backup there. So even if I have provided for them in my will or my trust, it might still be a great idea to utilize continuing care for that reason.
Thank you. All right, Harry, this next one is for you. Are investments placed in a trust managed by the trustee or a financial advisor?
Great question. It can go either way. Can you hear me okay?
Yes.
Okay, it can go either way. Some people just don't want to be bothered with it, and the trustee will manage that. In some cases, the trustee, if he or she is not sophisticated or knowledgeable about investments, may actually hire an investment manager. So there's complete flexibility. The trustee works on behalf of the person that set up the trust. The trustee could be the investment advisor. He or she could hire an investment advisor, or the donor could, the person, the trustor that created the trust, could specify a particular investment advisor. It is important, though, and I'll tell you, all investment advisors are great. And they never do anything wrong unless and until they do something wrong. So it is important to make sure there's a trap door, that if the investment advisor takes a bottle of stupid pills and does crazy things, you need to have the ability to have the trustee, or in some cases the trustor, replace that investment advisor. Far be it that should ever happen, but the trustor needs that as a safety valve.
Thanks, Harry.
You're welcome.
All right, and now James, would you expand further on the tax benefits of leaving an IRA to charity rather than to a family member?
Sure. One of the key things is the time that you're allowed for that deferral to continue. So under Secure Act, that timing has changed a little bit. So when I leave an IRA assets to a nonprofit, such as the Arizona Humane Society, I do get a charitable deduction offset for that on the income tax return. So there's a little bit of a play on the benefit and the deferral from a income tax payment perspective. So for example, if I've left 50% of my IRA to Arizona Humane Society and I've left the other 50% to a beneficiary, the beneficiary will pay tax on that IRA if it's a traditional IRA asset. The charity will not. So that's one of the key drivers of that. It could be that there's an acceleration event if you leave assets to charity. So you've got a 5-year payout versus the 10-year payout under the Secure Act. And historically, if there's a death prior to January 1st, 2020, we may still be able to receive the lifetime payout for the inherited beneficiary. But with Secure Act and with more recent deaths, we get a 10-year payout.
Thank you. So we do have some follow-up questions for the earlier fiduciary question. So Andrea, I'll throw those back to you. How do you find a certified fiduciary? Why wouldn't an estate attorney not mention this option to folks with a beneficiary? And what is the cost associated with a fiduciary? And are those likely to diminish the value of the estate and hence the real worth to the designated beneficiary?
Okay, so that, and I'll ask you to repeat the first part of the question, because I've got the cost and I've got the why wouldn't it be mentioned, but what was the first part of the question? Could you repeat that, please?
He said, how do you find a certified fiduciary, and why wouldn't your estate attorney mention this option to folks with a beneficiary?
So there are registries that you can search for those. I think the best way to find a professional fiduciary is to reach out to somebody that deals with professional fiduciaries and get a referral. You know, the folks that are licensed through the Supreme Court, there is a rather rigorous process to be licensed, and you can access names through that registry. However, like with most things in life, you're better off if you've got a recommendation from somebody that's actually worked with a professional fiduciary. I make recommendations a lot of times not just based on acumen, because of course I'm only going to give somebody's name out if I think they do a good job. But like everything else in life, there are certain personalities that mesh together better than others. There are certain fiduciaries who are better with different types of beneficiaries. And that's a very, very personal thing. So you can either access the list through the Arizona Supreme Court, or your better bet is to ask for a few recommendations. And after you've got a few referral names, picking up the phone, making the call, and making sure that whomever you select is somebody that you've spoken with. Ask questions about their particular practices, and get a feel for the way things would be run. As far as why an attorney wouldn't recommend it, a lot of times if I've got somebody who says, my sister, my son, my neighbor, if they've got an individual who can fill that role, it's not always brought up. There's like most things in life, there's benefits and drawbacks to both. So what's the benefit of having an individual serve in that role? Well, my neighbor or my sister or my adult son are in a position where, they know me. So from a personal perspective, you've got, that familiarity. And that's certainly worth something. What's the drawback? Well, my sister or my neighbor or my son don't do that for a living, and they've got jobs, and they may have families, and they may have other things to do. So it's a considerable amount of work. And if it's not your full-time profession, it winds up being a part-time one. What's the benefit of a professional fiduciary? Well, that's what they do for a living. They're familiar with notice rules, accounting rules, and all of those different types of things. What's the drawback? And this goes to the last part of the question, which is, what is the cost? Those vary from fiduciary to fiduciary. There are certain professional fiduciaries that have staff that charge, 35 to 50 bucks an hour for certain tasks. And then the fiduciary themselves charges, anywhere from $90 to $150 to $200 per hour for certain tasks. When we're talking about not just licensed fiduciaries, but there are trust companies and banks that can fill that role as well. Those are billed according to published fee schedules, and can be a percentage of the overall value of the estate. So that's a long way to say that it depends, but it certainly, when it comes time to interview a fiduciary, making sure that, number one, you're comfortable with their explanation of their role in an administration, and then having a frank discussion about fees. And if we're talking about, hourly based fees, do we have staff that bills at a lower rate to take care of sort of more basic tasks? So it's just doing the homework.
Thank you. So the next one I am going to throw to Troy, and it's, can you discuss a dynasty trust versus a regular trust?
So dynasty trust is one of those phrases that has a different meaning depending on what attorney you want to talk to about. But typically what it means is that it's going to last at least more than one generation, or at least is going to last for the next generation quite a while into it. So not a complete example of, I guess an example of a dynasty trust might be one where you leave your inheritance to your child or children, and it stays in a trust for the remainder of their lifetime. And then when one or more of when they die, it would be held in a trust for the grandchildren at that point, the children of the deceased children, maybe for the entirety of their lifetime, depending on what jurisdiction you're in, or maybe until they're 21 or 25. We have in the United States a thing called the rule against perpetuities that varies from state to state and depends on how long property can remain in trust. But the general idea is that behind a dynasty trust is that instead of any property ever going outright for full control by the children, it's going to remain in trust for them, typically for a number of protective reasons. It may be protection from creditors, it may be protection from divorce, it may be to make sure that the most advantaged tax aspects can be emphasized, but really what it comes down to, I think probably is the most general, is that it's dynastic. It's intended to last for at least more than one generation.
Thank you. All right, Lori, I'm going to ask this next one to you. If we leave our entire estate to AHS, can we name AHS as the representative / fiduciary?
I'm going to go with Andrea's answer of it depends. So yes, you can. What we usually tell folks is that we may, if it turns out to be a very complicated and involved estate, we may hire a fiduciary or an attorney to help us with it, which I know is not people's plans or their intents, but our plan giving team in-house is made up of Vanessa and I, which isn't very much. We have about 100 open estates right now that we're working on, which is a true wonderful blessing, but it's also a large caseload. So if an estate is left to AHS and we are named the fiduciary, we're named the beneficiary, and we're named in what in Arizona is called the personal representative, we would maybe consider hiring a fiduciary to help us. And we do that for several reasons. We do it because we want to be sure we do everything right. And as Andrea said earlier, they go through an arduous process to get that certification. And so we want to be sure that an attorney or a fiduciary is checking what we're doing. And we also do it from an audit standpoint. We go through a rigorous audit process that I absolutely love, because it means that we are doing right by every donation that we receive. And for me, that's the most important thing, is honoring the legacy that you wish to leave. So I know it's a terrible answer to say it depends, but you're more than welcome to leave it that way. And then our plan giving committee will meet with Vanessa and I and help us decide, okay, this is one that we can process ourselves in-house. We won't need a lot of outside additional help, or gosh, we better call somebody in and have them help us with this. But we do it each one on a case-by-case basis, because we want to be really responsible stewards of your legacy gift.
Okay, this next one I'm going to read, and I'm going to answer the first part, and then if Kathy, you want to jump in and maybe address it further. So this says, I have a revocable trust, but my vehicle and also one of my brokerage accounts are not in the trust. Earlier, Vanessa said that this makes the trust invalid. Did I understand that correctly? Is my trust invalid because some of my assets aren't in the trust? No, your trust is not invalid. And I'm sorry if that was confusing when I spoke earlier. So basically that was saying, if you set up a trust and then you don't actually transfer any assets into your trust, that the trust can be set up, but it basically is unfunded. So if you have transferred some of your assets into your trust and some of them have not been transferred into your trust, then some of those would be managed through the trust and some of them wouldn't. So for something like a brokerage account, you can name a beneficiary on a brokerage account and it can pass through to the beneficiary outside of trust administration or probate. So that's something where you can certainly keep that as it is. You don't need to transfer that into your trust. In terms of the vehicle, that I am unsure. So I will defer to our attorneys on that one. Kathy?
Yes, well, not having a vehicle titled in the trust, you're absolutely correct that that does not in any way affect the validity of the trust. The trust document is still valid. In most situations, when attorneys work with clients, we always have what's called a pour-over will as a safeguard and a backup plan, because sometimes people will buy a new asset, sell an asset that was placed in the trust, and then when they get the sales proceeds, they don't invest them in an account or an asset that's titled in the trust. So the will provide that if there should be an asset in a person's individual name that's not titled in the trust, then when the person dies, the asset should be, it says the residuary beneficiary under my will is my trust. Then you don't have to repeat all those distribution distribution provisions, beneficiary identification in the will and duplicating what's in the trust. You can just say, oops, if I forgot, didn't get it titled in the name of the trust, then pursuant to the will, that asset would be titled, would be transferred to the trust in the probate, and the trust provisions would apply. There is a provision under the law for small probate, where if the assets are worth less than $75,000 that are held outside the trust, then there's a procedure for transferring things like a vehicle, if it's not one of those super expensive Teslas or something, then it can be transferred pursuant to that affidavit. And there's also a form that the Department of Motor Vehicles provides where you can actually designate a beneficiary of your vehicle in that form, which the beneficiary can then take to Department of Motor Vehicles and have the title transferred. Does that answer everything, do you think?
I think so.
Okay.
Yes. Let's see. We have one more follow-up on the fiduciary question, which is, do certified fiduciaries and attorneys compete?
I think there are some attorneys that are licensed fiduciaries that, you know, there's the potential for competition there, but no, at least in my mind, they don't. The roles are very, very different. Again, you know, there are times where I've got a client that I've drafted something for where they've nominated a professional fiduciary. My client passes and the professional fiduciary comes to me and says, you know, will you represent me in my role as fiduciary over the estate assets or in my role as successor trustee?
Thank you. Well, I think that answers all of our questions. I do want to let everyone know we have had some people ask if they do include AHS in their will or estate, what do they need to do to let us know? You can definitely reach out to Lori or me, and we will be following up with an email to everyone with a survey. And so it'll have the contact information in there, and we can send you out the paperwork to recognize you as a member of our legacy circle. And then also we can send you continuing care paperwork if you do have pets you would like to enroll. So we can get your specific information, how many dogs, how many cats, how many critters from you to send you the right forms. And then I did just want to throw it back to everyone and say, is there anything else that we didn't talk about today that you think could be of value to the people who are listening? All right.
I don't think so. You did a great job, Vanessa and Lori.
Yeah, great job.
For the information.
Well, then I will just say thank you to everyone. And we will put our information back up on the screen so that you can reach out to us if you have any questions. And thank you to our wonderful Plan Giving Committee for participating and answering all those questions today. We appreciate it very much. And we also appreciate everyone who tuned in. We are recording this, so we are happy to share that recording with you. And again, we will be sending out a survey if you would provide us with your feedback so we know what we can do to improve this going forward. So thank you again, and stay safe out there, everybody.